G'day everybody and welcome to the Week 5 lecture in Laws 13010 Evidence and Proof. I'm Anthony Marinac. This week we've got the really good one. This is the lecture that people tend to look forward to in terms of evidence and proof, and if you're being completely honest with yourself, this is probably what you saw yourself doing when you first started to think about studying law. This week we're going to look at the examination of witnesses. The examination of witnesses is the central element of legal advocacy. If you have ambitions of being a great trial lawyer, if you have ambitions of spending your time on your feet in court, and certainly if you have ambitions of going to the bar, advocacy is going to be how you make your living. And within advocacy, the most important skill is to be able to effectively handle witnesses. Today we're going to look at the rules and the basic practice of the examination of witnesses. We're not going to be able to teach you to be a great advocate in the space of 40 or 45 minutes. However, we can cover the basics and hopefully whet your enthusiasm for what really is a very interesting and fascinating exercise. During the course of the lecture and during the course of the week, we're going to look at the process of preparing or proofing a witness. We're going to look at the three types of examination of witnesses. Those are called examination in chief, cross-examination and re-examination. And so we'll look at the rules binding each of those types of examination of witnesses. We'll talk about hostile witnesses and what's meant by that term. We'll talk about what's called the rule in Brown and Dunn and why it's important. And finally, we'll move away from the legal analysis of questioning witnesses and start to think about some of the different types of questions that can be asked and why you might use each of those types of questions when examining witnesses. When I first studied advocacy, I learned my advocacy from a lecturer by the name of Hugh Selby at the Australian National University, and he used to say the three most important things when it comes to advocacy are preparation, preparation, and preparation. And it's absolutely true. Very rare indeed is the advocate who's going to be able to successfully walk into court and wing it. The truth is that you want to walk into court knowing more about the witness's evidence than the witness does. You want to walk into court knowing what you expect them to say, how they expect to say it, and more importantly, you need to think about what you're going to do to draw their story out and place their evidence before the court. This requires different preparation for your witnesses and the other team's witnesses. In relation to your witnesses, you need to know what evidence they're going to give. The last thing you want is surprises from your own witnesses. Remember, evidence is all about convincing the court to believe that your version of the facts is true. Evidence is only relevant if it makes a fact in issue more or less likely. So that the evidence that you're hoping witnesses will give has to be calculated to make sure that the facts you're trying to present to the court will seem more likely. So you need to know what evidence they're going to give, and you need to be very clear about how this is expected to help your case. The third thing you need to think about in relation to each witness is the risks that they pose. Every witness will have advantages and disadvantages. Some witnesses may be great on technical aspects of their evidence, but they may not be personable, and there might be a danger that they simply won't come over as someone to be trusted. There might be people who are likely to know what they're talking about but will give poor presentation in the courtroom. There might be people who will look great and sound great, but the truth is that you can't really rely on their memory, and there's a chance that they're going to fall over in cross-examination. You need to think about the strengths and weaknesses of each of your witnesses, because the strengths and weaknesses of each witness will end up being the strengths and weaknesses of your case. You then need to think about the other side's witnesses. What evidence are they going to give, and how is that going to harm your case? Think about why they're wrong. I mean, clearly, if they're trying to convince the court of a set of facts that you don't believe, there must be something about the evidence you're expecting them to give where you think they've got it wrong. Be prepared to question them about that aspect of their evidence. Be prepared to try and limit or remove the harm that they can do to your case. Think about and ruthlessly exploit the vulnerabilities that they have in terms of their evidence, but do so within the rules of evidence and within the rules of court. Because one thing that won't help you win any case ever is a cranky judge. Benjamin Franklin said, "By failing to prepare, you are preparing to fail." Me, I actually prefer another story. You can read the long version of this story in the notes, but I'll give you the quick version now. Pretty much everyone will know the ice skater Steve Bradbury. You've all seen the footage. Coming around the ice on the very last turn of the gold medal race in the speed skating at Salt Lake City in the Olympics. He's coming last. He's coming last by quite a way. And on the last turn, the very final turn, less than 15 metres to go before the line, everyone else crashes out. And he cruises on through and takes the gold medal. Steve Bradbury has become a byword in Australia for winning by luck or winning by just hanging in there. People forget he didn't just end up in that race because he turned up to Salt Lake City and said, "Can I have a go?" He won that race because he put in 12 years of preparation that brought him to the point where he could be on the ice in the Olympic final just behind the 4 other best skaters in the world. That's how he won his gold medal, not because everyone else fell over, but because he did the years of preparation that put him in exactly the right place, in exactly the right time, to be the one who cruised through and got the gold medal when everyone else fell over. Preparation, preparation, preparation. One very specific aspect of preparation that we need to talk about is witness preparation. You don't want to be meeting a witness for the first time when they take their oath and stand up in the witness box. You need to make sure that the witnesses you are going to be presenting to the court are adequately prepared to give their evidence. You need to meet with them all before court day. You need to have a discussion with them about what to expect when they turn up, what the procedures are going to be, what sorts of people they're going to see in the courtroom. Then you need to work through the evidence that they're going to give. Ask them if they've thought about the incident. Go through some questions that you're likely to ask them and see what sort of answers they're planning to give. Maybe review a statement if they've given a statement previously in the proceedings. When you're doing that though, you have to realise that there's a fine line between proofing and coaching. Proofing is the process of assisting the witness to give their evidence. Coaching is the process of telling the witness what evidence you want them to give. Coaching will not only lose you the case, it may well cost you your place on the roll of solicitors. Coaching is unlawful and it can prejudice the effective administration of justice. The other thing you need to do in the process of witness preparation is prepare for cross-examination, particularly if you expect the witness to have a torrid time in cross-examination, or if you've identified vulnerabilities that you think your opponent is going to exploit. Do some role play, put them under pressure, make sure that by the time they get into the courtroom they are well and truly ready to do their best to assist you to prove the facts that you need to win the case. So now it's court day. What is the course of a trial when you turn up? We're going to talk mainly about a criminal trial in this context because most evidence law seems to revolve around criminal trials, and you've got another subject to do in civil procedure anyway, so you'll pick up the civil trial stuff when you do that subject. In a criminal trial, the first step in the trial is known as arraignment. Arraignment is when the charge is formally read to the accused person to make sure that they understand what the charge is against them, and they are required to plead guilty or not guilty. If they plead guilty, we can go straight to the verdict and straight to the sentencing process. But that's no fun, so let's assume that they've pleaded not guilty. If they've pleaded not guilty, the next formal stage will be the the swearing in of the jury. After the jury's sworn in, the prosecution will open its case. The prosecution always goes first in a criminal trial because the prosecution bears the onus of proving every element of the crime to the criminal standard, which you will remember is beyond reasonable doubt. So the prosecution has to start and has to convince the judge that all of the elements of the crime are met to the criminal standard of proof. They begin with an opening address where they lay out the facts as they say exist in relation to the criminal offence. Having laid those facts out, they then need to prove them. At this point, the prosecution will call its witnesses, and its witnesses will go through the process of examination in chief, cross-examination and re-examination. We'll talk more about those in a few minutes' time. At the end of all of that prosecution evidence, the key question asked by the court is there a case to answer? You see, if the prosecution has presented all of its evidence and it hasn't demonstrated that each of the elements of the crime exist, the defence don't need to open their mouth. The defence can quite simply say, we move that the court recognise that there's no case to answer, and if the court agrees that there's no case to answer, the accused person is acquitted and the accused person goes home happy. They're released. But again, that's no fun. Let's assume that the prosecution has established a case for the defendant to answer. After they've done so, the defence opens their case. They open their case by setting out the facts as they say exist, and then the defence calls its witnesses to support those facts. When the defence has finished that process, they sum up their case, leaving the last word to the prosecution. Once the prosecution has summed up its case, we then go have our verdict, and if the verdict is guilty, we have a sentencing process. If the verdict is not guilty, then the accused person is released and the lawyer gets rich. So now we're going to focus on just two elements of that criminal trial: the point at which the prosecution witnesses give their evidence and the point at which the defence witnesses give their evidence. Each witness faces three types, or at least two out of three types, of questioning. First, examination in chief. Second, cross-examination, that's the one everyone sees on the movies. And third, re-examination. It is absolutely vital that you understand the difference between the three and understand the rules that apply to them. I can almost certainly guarantee that there will be questions on this in the exam. Let's start with examination in chief. Examination in chief is the first part of the process, and the idea of examination in chief is that the witness is going to tell their story to the court. What the court wants to hear is the witness's story in their own words, in their own way. As a result, what are called leading questions, which are questions answered with a yes or no, are not permitted. You see, if we want to hear the story in the witness's own words, it makes no sense for the lawyer to be saying, were you at this shopping centre on the night of the 25th of April? The witness says, yes. Did you see anybody resembling the accused person at that location on that night? The witness says, yes. Did you see whether they stole anything from the Dunkin' Donuts shop? And the witness says, yes. We're getting the story, but we're not getting it from the witness at all. So during examination in chief, questions have to be open. They have to be an invitation to let the witness tell their story in their own way. That's the key point about examination in chief. No leading questions, lots of open questions. However, as I keep saying, this is evidence law and there are exceptions to every rule. There are three times you might ask leading questions in examination in chief. First is if you're introducing the witness to the general topic. So if your opening question just indicates to them what events you're talking about, particularly if there's two or three different charges being levelled against the same defendant, that's not really a problem because it's not preventing them from telling their story. It's just really telling them which story you're asking them to tell the court. Second, You might be allowed a few warm-up balls, a few opening questions to a witness to let them get over those first jitters at being in the witness box and build up their confidence. Those questions don't prevent the witness from telling their story to the court. They actually kind of enable the witness to tell the story to the court, because rather than sitting there nervously and blowing their first few important questions, we let them blow a couple of inconsequential ones so that they're warmed up by the time they come to the important stuff. The third time you can ask a leading question in examination in chief is to test propositions from previous evidence. You see, if someone else has given evidence where they have made an accusation towards the current witness, it's only fair that you put that accusation to the witness and give the witness an opportunity to respond. So let's say that, the example that I've given there in the slide, let's say that our previous witness named Williams has said that the current witness is going to give false evidence against the accused because the accused is gay and the current witness is prejudiced towards gay people. It would be perfectly fair to say to the current witness, the court's been told that you don't like gay people. Is that true? It's a leading question, but it's a leading question that's allowed under the circumstances, because it would be very difficult to ask open questions which could guide the witness to actually refuting the allegations that have been made against them. I'd like you to remember those three exceptions, but what I really need you to remember is the rule. Examination in chief is all about the witness telling their own story. Leading questions are not allowed to be used in examination in chief. Next we get to cross-examination. Cross-examination is hard. Cross-examination requires you to be able to think very quickly and speak in a very articulate way on your feet against somebody who doesn't want to help you, somebody who's not necessarily there to assist you, because cross-examination is when the other side's lawyer gets up to ask questions. So if we've called the witness, we get up and ask our questions in examination in chief, and then we sit down. And then the other side gets a turn. That's the cross-examination. Why do we cross-examine? First, we cross-examine to test the evidence which was given during examination in chief. Second, we cross-examine to try and show that evidence which doesn't suit our case is either unreliable or has low probative value. You remember that we've been talking about these aspects of evidence since week 1, and we've been talking about them as ways to knock evidence out from our opponents or ways to support our own case. If you can show that a particular witness is giving evidence that is not reliable because it goes beyond the limits of perception, or because the comprehension that they have put on those perceptions is flawed, or if you can show that their memory of the event is very different to the memory of other witnesses, or if you can show that their narrative is dishonest either deliberately or because it's simply beyond the limits of honesty, you can show that the evidence is unreliable. If the evidence is unreliable, it's more likely that the court is going to believe your version of events and that you're going to win the case. Cross-examination is where you get to ask the questions designed to show the unreliability of the other side's evidence. Finally, you can use cross-examination to show that the other side's evidence has low probative value. This is kind of listening to the other side's evidence and then asking the question, so what? Let the witness give their evidence, but then try to show that it doesn't actually prove anything by asking them more questions. During cross-examination, unlike examination in chief, leading questions are allowed. You're allowed to ask any leading questions that you like in cross-examination. That's probably come as a surprise to you, because a lot of people think that leading questions are not allowed in court at all. It's actually not true. Leading questions are not allowed in examination in chief, but they are perfectly okay. In fact, they are almost normal in cross-examination. Having said that, there are limits. In court in Australia, you are not allowed to torture a witness by placing them under duress. This is one of the reasons why counsel in court are required to stay at the bar table. We don't have that thing that you'll see in American courtrooms where a big, hulking, aggressive lawyer walks up to the edge of the witness box, puts their arm on the railing of the witness box and looms over the witness, placing them under duress whilst asking their questions in a loud and aggressive voice. We don't do that in Australia. It's not allowed. Questions that are simply designed to upset the witness will not be allowed. And then there's a list of question types that are improper. They're either misleading, confusing, annoying, harassing, intimidating, offensive, oppressive, or repetitive. They're not allowed. So if the other side starts asking those sorts of questions, that's a great opportunity to jump up and object to the question that's being asked. Cross-examination is allowed to be aggressive. It is allowed to be assertive. After all, the witnesses are doing their best to dismantle your case. But at the end of the day, cross-examination is not allowed to be a form of torture, and it's not allowed to be a form of offence, and you're not allowed to take advantage of inherent vulnerabilities in the witness by aggressively intimidating them. Ultimately, all that matters in cross-examination is you don't think their story's quite right, and you need to ask the questions that will show that. The best cross-examiners that I've ever seen demolish witnesses without so much as raising their voice. Logic will do the job every time. Within cross-examination, we come across a curious beast called the rule in Brown and Dunn. It's called the rule in Brown and Dunn because the rule was originally established in an 1860s case called Brown and Dunn. In Australia, however, the most common expression of the rule, the most authoritative expression of the rule, was given in the New South Wales Supreme Court in the case Allied Pastoral Holdings and the Federal Commissioner of Taxation in 1983. You can use either of those references if you're discussing the rule in Brown and Dunn in essays or exams. But the rule is not known by any name other than Brown and Dunn. So what does the rule mean? The rule says, if in the summing up of your case you're going to contradict the testimony given by a witness, you have to put your version to them during cross-examination. So in other words, if the witness says, it was light enough in the car park for me to see the offender clearly, if that's what they've said, and you're intending to sum up by saying half the lights were out in that car park, so it would have been impossible for anyone to see the offender while the offender was moving through the car park, that's okay for you to have that view. But while that witness is in the box, while they are saying that it's sufficiently light for them to see the offender, you have to put your alternative proposition to them. You have to say to them, well, you've just said to the court that it was sufficiently light for you to be able to see the offender as they moved away from the scene of the crime. But we have other evidence before the court which suggests that half of those lights were out and it was impossible to see at any great distance. It was certainly impossible to see colours at that time of night with that low level of lighting. Now, one of two things will happen when you say that. Either the witness will deny that and they'll say, no, there was plenty of light, I could see everything, or they will stutter and stammer and start to look very unreliable. The bottom line, however, is that you've got to give them a chance to defend their evidence. If you're going to contradict their evidence, you have to give them a chance to defend it. We're going to have another look at the rule in Brown and Dunn when you look at the scene from the movies that we look at this week, and the practical application of the rule will make it seem a lot more easy to understand. Once cross-examination is done, we come to re-examination. Re-examination doesn't always happen. Re-examination happens under two circumstances. One, if your witness has said something in cross-examination and it's really clear to you that what they've said has been misinterpreted, or that they misunderstood the question, or that something has come up during that cross-examination that needs to be clarified, then you can ask for the opportunity to re-examine the witness, and you can ask them questions specifically intended to clarify that particular situation. The second thing you can do in re-examination is ask questions about cross-examination if the cross-examiner raised issues that you never thought to raise in your examination in chief. So if the cross-examination has produced some evidence in an area that just was completely unexpected to you, and the evidence has gone badly and you need to correct it, you have an opportunity in re-examination to get up and do so. And that's kind of fair, because it means that the side that called the witness and had to go first then gets an opportunity to listen to the cross-examination before having one last chance to get their witness to clarify or cover again the ground that has been traversed by the cross-examination. There's a couple of things that you can't do in re-examination. First thing is, you can't introduce new topics in re-examination, and that's fair, because the cross-examination, the other side, are not going to get another chance to talk to the witness. So it would hardly be fair to raise things with the witness when the other team is not going to get another chance to talk to them. The other thing that you can't do in re-examination is simply go over again the evidence that was given in evidence in chief, so that you've got two bites at the cherry and you're hoping that it will seem twice as compelling, or you weren't quite happy with the way it was answered the first time round. You're limited to things that were discussed in cross-examination, and you're limited in purpose to trying to explain or clarify the evidence that was given in cross-examination. So re-examination is quite limited in scope, and it usually proceeds a lot more quickly than examination in chief or cross-examination. The one other thing that you'll see a lot of during examination of witnesses is objections. The court has the capacity, the court, as we've discussed in previous weeks, has the general authority to make sure that justice is done in the courtroom. So if a witness is being asked questions that are clearly improper, clearly unacceptable, there's every chance that the judge is not going to wait for an objection before they jump up and tell the questioning lawyer to pull their head in. However, generally speaking, the court will rely on the opposing counsel to make the objections. If you hear a witness ask questions that they shouldn't be asked, so for instance, if the other side is conducting examination in chief and they start trying to do it by asking leading questions, you're entitled to object, state the nature of the objection, and then the judge will rule whether the question is acceptable or not acceptable. Importantly, if you fail to object to a question, you are impliedly accepting that the question was okay. Don't rely on the bench to object to the questions that you don't like. If there's something wrong with the question, you have to be the one jumping up to object to the question, seeking a ruling from the judge. So that's our different types of examination. Next thing I want to talk about is a hostile witness. This is one of those really misleading terms that you come across sometimes in law, because when I talk to you about a hostile witness, your first thought is probably a really cranky witness, an angry witness who objects to being there, or who doesn't like being cross-examined, or doesn't like having their evidence questioned, and who's getting upset and angry and waving their fists in the air and carrying on like a pork chop. That's not what we mean by a hostile witness. A hostile witness is a witness that you've called, and you've called them because they've told you they're going to be able to give certain evidence, and then they get up in the witness box and they give either completely different evidence or they fail to give evidence at all. So this is the situation where the witness has told you several times that they saw the car driving away from the scene, they saw that it was a red Subaru Impreza, and they saw that the person driving it fitted the description of the defendant. You get them up in the box and you say, "What did you see that day?" And they say, "Nothing." They say, "Did you see a red Subaru?" If you're lucky, you'll get the question through without anyone objecting to the fact that it's leading, and they say, no, I didn't see anything. What you're starting to think is that the witness is being deliberately unhelpful. If the witness is being deliberately unhelpful, if the witness is failing to give the evidence that you were expecting them to give, you can apply to the judge to treat the witness as a hostile witness. Once you're treating them as a hostile witness, it is as though the other side had called them. So you can cross-examine them. You're no longer limited to asking only open questions. You can ask leading questions, and you can ask a limited number of questions intended to reduce their credibility. So you would be asking them, for instance, whether they have told anybody in the past that they saw a red Subaru Impreza. Or you might be asking them whether or not they've given statements in the matter, and generally hinting at the fact that for some reason they're now deciding not to be helpful. Once you've finished cross-examining, the other side will also get an opportunity to cross-examine. So the hapless hostile witness gets cross-examined twice. Now there's a difference between a hostile witness and a witness who turns out to be a bit surprising. The mere fact that a witness says stuff in the courtroom that is different from what they said to you when you proofed them before the court does not make them a hostile witness. They're allowed to change their mind, they're allowed to change their evidence, they're not bound to say in court what they told you they would say when you proofed them. However, if the nature of the change in evidence is so strong that it's clear that they are not cooperating with the court, then they become a hostile witness, and there's an opportunity for you to apply to the judge to treat them as a hostile witness and cross-examine them rather than leading an examination in chief. So that's the process of examining witnesses. We've talked a little bit already about some of the types of questions that we asked. I want to look at them in a little more depth. We'll start with open questions. Open questions are questions which provide somebody an opportunity to tell a story. So when you get home from work and your spouse says to you, "How was your day?" That's pretty much an open question. It's an invitation to you to tell them the story of your day. I've got some examples there on the slide. What did you do on the night of the 31st of October? That is an open question because it invites the witness to tell a story. Now, when you're examining somebody in chief, what you're going to have to do, and it can be quite a difficult skill to learn, you're going to have to use open questions to continue to prod the story along and to direct the story in the way that you need it to go to cover all the factual ground important for the case. So you can see the 4 questions that I've listed there on the slide indicate how you might do that. So your first question to the witness, what did you do on the night of the 31st of October? The answer might be something along the lines of, I went to a nightclub with a few friends. Okay, so they've said something about the nightclub. That's important. That's where we want them to be. Let's develop that bit. So the second question becomes, what happened after you got to the nightclub? Again, it's an open question. It's an invitation to tell a story. Oh, it was a pretty good night. We had a few drinks. We danced with a few girls. And we cleared out just after a fight started in the bar. We asked them, well, let's say that when they were describing the fight, they said that the fight was between 2 men who started by shouting at one another. So the third question becomes, once those 2 guys started shouting, what happens next? Well, one of them smashed a glass and took a swing at the other one, and then everything descended into noise and chaos. I saw the bouncer pick one of them up and he tossed him outside. I went outside too. So when you followed the bouncer outside, what did you see? I saw him pounding the head of the guy into the pavement, whatever it might be. What you can see is that we use a series of open questions to shape and direct the evidence that the witness is giving, but at no time are we giving the witness the evidence and asking them simply to confirm it. We're using a line of open questions to guide the witness so that they can tell their story, and so that they're not entirely responsible for the narrative. We're assisting them to tell the story that we think the court needs to hear. Open questions can be surprisingly difficult to run, because when open questions are being used, you do lose some of the initiative of the narrative to the witness, and so keeping them within bounds and still using open questions can be very challenging. Closed questions, however, ask for an answer in just a few specific words. So, what colour was it? How hot was it? How long did you wait? These are all closed questions because they ask for a fairly short, very specific answer. How many years were you at university? What was your mum's name? Okay, you can see that these questions don't invite a narrative. Closed questions are great for clarifying small aspects of a story, and they're great during cross-examination when you're not really interested in giving the witness an opportunity to tell more of their story. What you're interested in doing is getting the witness to clarify specific aspects of their evidence that you think are either wrong or unreliable. A very specific type of closed question is the leading question. Leading questions require a yes or no answer, and that's it. So anytime somebody prefaces a question with yes or no, you can tell they're about to ask a leading question. In this situation, the lawyer's the one telling the story. The witness is not telling the story at all. The witness is simply agreeing or disagreeing with propositions that are put to them by the lawyer. Leading questions are very commonly used in cross-examination. One thing that you will see, however, is that in cross-examination, lawyers will treat yes as though it means no, and no as though it means yes. Have a look at the example there. The lawyer says, "You went there that night to start a fight, didn't you?" Witness says, "No, I didn't." The lawyer completely ignores that answer and says, "And when you got there, you decided that the accused was going to be the target of your attack, isn't that right?" And the witness says, No, it's not like that." Can you see how no matter what the witness says, the lawyer just continues to build a narrative that has nothing to do with the witness's evidence? Now, if you took away the witness's answers and just read those two questions again, you went there that night to start a fight, didn't you? And when you got there, you decided the accused was going to be the target of your attack, isn't that right? It starts to build a narrative that is damning to the witness. If you find that your opponent is starting to ask leading questions and ignore the answer, that's a great opportunity to get up and object and remind the judge that in fact the witness denied the previous answer, so there's no foundation for the current answer. Sometimes you'll win the objection, sometimes you won't, but at the very least you will have alerted the courtroom to the fact that your opponent is essentially crafting a narrative and putting it out there in front of the court regardless of what the witness might say. Next type of question I want to talk about is called a probing question. Probing questions ask for clarification of a previous answer. They allow you to dig a little deeper. They're great when a witness is being evasive. They're also great when a witness is lying. What you can see there is a snippet of evidence that I've just made up. The first question that's been asked of the witness is, "What happened when you went to his place?" Now, another witness might have answered fulsomely and immediately. They might have said, "Well, when I went to his place, we watched a DVD and later on we had sex." That would be great. That would be a very cooperative witness and a great way to get evidence with an open question. However, in this case, we've asked the open question, "What happened when you went to his place?" And the witness has been kind of evasive. "We sat on the couch and spent some time together." Now you can see that's not a lie. They did sit on the couch and they did spend some time together. But by the same token, the witness isn't telling you what you actually want to know about what happened after they got back to the house. So you ask a probing question. When you say you spent some time together, what were you actually doing? And the witness says, "Well, first we watched a DVD and later we kissed." Now, because the witness has given that answer, you can then ask a further probing question, but in this case a probing closed question or probing leading question. Did you have sex? So you're asking the witness to be very specific about clarifying one aspect of the evidence that they've given. What you can see is that series of probing questions has enabled you to gradually wear away at a witness who was trying to be evasive in the first place. Probing questions can be terrific if you have a witness who you think is telling you lies. Because most witnesses, indeed most people in general society, when they're telling lies, have usually thought about just enough of a backstory to the lie to get away with it. And they bring in that prepared lie. But once you start probing and asking them questions that go beyond the backstory that they've prepared for the lie, they have to start making stuff up. And once they start trying to make stuff up, you're very quickly going to start spotting the logical gaps. And once you start spotting and exploiting those logical gaps, you can show the court that the witness is lying, and the witness's reliability will be the evidence's reliability will be in tatters all over the floor. So probing questions can be terrific. Police use them a lot in their interviewing, and they're well worth learning if you're going to be a successful advocate. The next type of question is the rhetorical question. Rhetorical questions you're not usually going to get away with, and neither should you, because rhetorical questions are not really questions at all. They're just a statement that's designed as a question. So the witness has said, the police officer used his taser and I fell to the ground. That's when I sustained my head wound. There was no need for him to do it. The lawyer, perhaps quite rightly, has said, you confronted police with a knife in your hand. What did you expect them to do? When the lawyer asks that question, he's not actually asking the witness what he expected the witness to do. What he's really saying is, it was perfectly appropriate for the police to taser you. So it's a statement that's phrased as a question. If your opponent starts using rhetorical questions to sneak in statements that the witness isn't making, that would be a good opportunity to object. Finally, let's talk about hypothetical questions. Hypothetical questions suggest a pretend circumstance, and they ask for the witness's reaction to that circumstance. There's a sort of an assumption out there that hypothetical questions are inherently bad. They're actually not. And if you think back to things like your tort law and your contract law, then you'll remember, and even criminal law, you'll remember that we have subjective and objective considerations in relation to a lot of matters. Objective considerations ask, what would the reasonable person do in that situation? That question is a hypothetical question, because there is nobody out there named Mr. or Ms. Reasonable who we can go and observe in the community doing their thing. What we're asking is, what would a hypothetical person, who is a reasonable person in the sense of the community that we're talking about, likely to do under those circumstances? So hypothetical questions can be fine. And I've given an example there of a series of hypothetical questions that I think would be fine. You've asked the witness, how did the child react? The witness said, he was clearly hurt, but he didn't cry. It was strange. You want to develop the idea of this strangeness. And so you say, well, how would you expect him to have reacted? So you're saying, hypothetically, how do you think he ought to have reacted? And the answer was, his ankle was pretty badly twisted. I'd have expected most children to be screaming. What that leaves you with in terms of evidence is not just the observation the child didn't cry. You've got the far more interesting piece of evidence that says the child didn't cry when he should have been screaming. So the hypothetical question in that case was quite useful. Where hypothetical questions become dangerous, though, is where lawyers who are halfway to losing a case suddenly realise that the facts just aren't suiting the argument that they're trying to run. If the facts aren't suiting the argument that they're trying to run, it can seem very enticing to just ignore the real facts and make up your own, and posit these hypothetical situations and ask the witness to respond to them. If that's what's going on, it shouldn't be allowed. Jump up and object to the hypothetical question. Finally, and I realise this is taking the lecture a little bit over time, I just want to alert you to some sneaky tricks that you're likely to see during the examination of witnesses. The first sneaky trick is asking for ever more detail. Now, we've already said that this is something you can do when you think someone's lying, and in my view that would be quite legitimate, but it can also be used as an illegitimate sneaky trick. You remember back in week 1 we said that never will you find the situation where all of the facts, all of the data are collected by anybody. And then we talked about the limits of perception. We said that humans don't notice everything. And then we talked about the limits of memory and said human memories don't record everything. The logical consequence of that is that if you ask people detailed enough questions about anything, they're not going to be able to answer. Why would a lawyer want to do this? Well, if they want to make it seem like the witness shouldn't be regarded as a reliable witness because they're suffering from the limits of perception or the limits of comprehension or the limits of memory, one way that they can try and do this is by asking ridiculously detailed questions and then making a big fuss out of the fact that the witness can't remember the answer. That'd be a good opportunity for you, perhaps in re-examination, to jump up and ask the witness to reconsider some of that evidence and explain to the court why it was that they weren't remembering trivial and inconsequential details. The second sneaky trick is called positing a premise. The answer there, the question that I've got there, the example is, what colour was the car you stole? That question builds in the idea that the car was stolen. If the witness answers red or blue, the witness has impliedly accepted that they stole the car. And yet the witness would have to be thinking very quickly to come back with the answer, well, I didn't steal the car. Questions that have that sort of a premise built in are questions that you probably shouldn't be allowing your opponent to get away with. The third one is a mouthful of Latin called post hoc ergo propter hoc, which translates as after it, therefore because of it. This is where people say that two events that happened in sequence were somehow causally related. So you had an argument with your girlfriend and 20 minutes later her car was damaged. The obvious suggestion there is that the defendant, after having an argument with their girlfriend, has gone outside and damaged the girlfriend's car. In fact, there's no logical connection between those two events. The fact that there's a relationship in time doesn't actually say anything about logical connections at all. There's a great study that was done, and you can Google this if you like and get a good laugh out of it. There was a great study that was done looking at climate change and global warming. And what they found was that global warming was inversely proportional to pirate activity in the Caribbean. So during the late 19th century and early 20th century, as pirate activity in the Caribbean drew down to a close, global warming in the world started to increase. So they suggested the argument that if we really want to take care of global warming, what we need is more pirates, because more pirates should mean less global warming. It's nonsense. It's nonsense because there's actually no relationship between those two things other than time. Don't allow your opponent to start suggesting that there are relationships that are simply time-based unless they can show a greater connection between the two. Finally, reversing the onus of proof. Reversing the onus of proof is where they put the onus on the defendant in particular to show that somebody else committed the crime. The burglar alarm sounded and you were seen running down the street. If you didn't break into the house, then who do you think did? Now that sounds a little bit laughable, but a case that I've mentioned to you before was the case of Schapelle Corby, who's still in prison in Bali for drug smuggling. One of the reasons that was expressed for finding her guilty, one of the reasons that the judges in Indonesia expressed, was that the defence had not been able to show that anyone else was responsible for putting the drugs in Ms. Corby's bag. Now in Australia, the prosecution would have been responsible for showing that she didn't, and there would have been no suggestion that she should be responsible for showing that somebody else did. You can see there the reversal of the onus of proof. Happened in Indonesia, it would never happen in Australia. So there are some sneaky tricks to watch out for. So during this topic, we've looked at the vital importance of preparation. You must prepare and prepare and prepare. Think Stephen Bradbury. We've talked about the process of proofing a witness and the fact that coaching is not allowed. We've talked about the 3 types of examination and the rule in Brown and Dunn. And we've looked at some questioning techniques: open questions, closed questions, leading and probing questions, rhetorical and hypothetical questions. Now this week in the movies we're going to look at an absolute classic, and most of you will have read the book, I suspect, back when you were in high school. We're going to look at the movie version of To Kill a Mockingbird, and in particular we're going to look at Atticus Finch's cross-examination of Mayella Ewell, who has accused Tom Robinson of raping her. What you'll see is a very straight-laced, very sober cross-examination of a very emotional witness. You'll see the interaction between logic and emotion, which is characteristic of cross-examination. And then there's a series of questions for you to answer, which will get you thinking about what's actually happening in the court once you strip away the immediate impressions of what you've seen. I hope you enjoy it, and I'll look forward to talking to you all again next week.